Good evening. This is Rahul Reddy. Today is February 6th. The time is about 5 p.m. Reddy Neumann does bring in live immigration updates every week at the same time. Emily, what do we have today? Too much action going on in the Senate and too much action going on in the House, and in two different ways.
Yeah, very different. So on the House side, there's a bill that actually passed the House that is dealing with DUI, driving under the influence, and how that will impact people who are not citizens in the U.S. So we'll talk about that, what it looks like going forward, what to be concerned about. And then we have the big news of the border bill that surprisingly has some employment-based immigration provisions in it. Typically with these kind of border or more enforcement bills, we see a lot of negative things that they want to propose for high-skilled immigration, but this one has some positive things. We'll talk about what those are and what are the prospects for it to pass, what's that process look like going forward. And then we want to talk about the 60-day grace period, dispelling some myths on whether you can get it one time ever or do you get it every job change? How often can you get the 60-day grace period when you are between employers in a non-immigrant status? And lastly, we're going to talk about helping your parents apply for the green card for those that are permanent residents in the U.S. or citizens. Is it better to consular process or file for adjustment of status? What does each process look like? What's the difference and which one is better than the other? So I want to start with this bill. This is HR 6976 because the congressman in Alabama who wants to pass this bill is specifically targeting illegal immigrants. So apparently he has some friends that were sadly killed in a motorcycle accident, and it involved an undocumented immigrant who happened to be under the influence. So he is trying to get this bill passed that will cause the deportation of illegal immigrants who are arrested and convicted of driving under the influence, whether it's drugs or alcohol. What he doesn't realize is that when he uses the word alien in the legislation, he's talking about anyone who's not a citizen of the U.S. That means people who are legally here. So it would impact legal immigrants as well. So I think there's just some very bad language in this. But yeah, he's basically making anyone who's not a citizen would be deportable if they're actually convicted of a DUI. And then if they are convicted or admit to a DUI, then they're also inadmissible, so they can't receive a visa or come into the U.S. So it passed the House. What do you think about that?
Well, it's very extreme, Emily, and of course, ex post facto law. I'm forgetting Latin. I know some of my clients are reminding me, is that typically when a criminal law is being passed, though, it can't act retroactively. At the same time, if it's not punishable at the point of time, or it's only punishable for less, they can't increase the punishment at a later date when it doesn't. When, for example, if I do a theft, if it's only 6 months crime, they can't pass a bill saying that anything which was been done previously, they will increase the punishment. They can only going forward, though. However, this bill, Emily, is not a criminal bill. So this is a civil, because immigration is civil matters. So anybody who has been in DUI, who have having a green card right now, can get kicked out of this country with this bill. When I read this bill, and surprisingly, this bill is passed in the House. It's not just it's not that it's discussed. It's just passed in the House with a good majority. I think so. All Republicans and about 59 Democrats voted for this bill. Now, the only thing is that if it's going to be passed in the Senate, all those people who have a DUI, whom we previously told the people that, hey, you will not have any problem in maintaining the green card. Yeah, there are some issues when it comes to citizenship that you need to mention it, and if it's been done within 5 years, you may want to delay your citizenship. But now this bill does not even allow the green card holders to stay in the United States and get the citizenship at all. This is a very drastic bill, the way it's been designed and worded and I don't know how if this is going to be implemented, what's going to happen to all those people who have DUIs. Now, when they are saying convicted, Emily, the immigration definition of conviction means that even if a person pays a penalty, they don't have to go to jail. If they pay a penalty, and let's say, for example, they do some community service, it's considered to be conviction according to the immigration law. That means that most of the people that go under the DUI, 95% of them will be considered to be convicted according to the immigration law and will be thrown out of the country. That's a very major thing, though.
Yeah, we already are at a point where we don't have the resources to deport everyone who's in the country without status. Now we're going to add people who actually have status and say we're going to deport them if they've ever been convicted of a DUI. I'm just not sure how they think they're going to have the manpower to accomplish that. So we'll see. Obviously, it has to Senate first, and then it has to be signed into law by the president. I've not found anything where it is actually being put forward in the Senate yet. And no one's really talking about it in the Senate because everyone's focused on the border bill rather than this small bill.
Well, we'll keep you updated, guys, on this issue. For those people who have a DUI, who've been waiting for the citizenship, I want them to apply for citizenship as soon as possible and get over with it. In that way, we may have some, once you get the citizenship, definitely they can't deport you for the DUI. Let's go to the next thing. There is a lot of speculation, Emily, going on in the Indian newspapers that all the H4s are going to get an employment authorization if this bill passes through, border bill, which is in the Senate right now, but the House Republican, the Speaker says that he's not going to even present it. It's dead on arrival. So let's speak about what are the immigration provisions in this bill, Emily, which the bipartisan Senate committee, they put this together and they said they are going to pass in the Senate.
So, yeah, it does have a provision that provides H4s with work authorization, whether it's a spouse or a child, without needing a separate EAD card. So it's kind of like how they finally properly implemented the L2 statute that allowed L2 spouses to work without having to apply for an EAD. So this would potentially allow both spouses and children to work, which right now children can't work whether you've got an approved I-140 or not. So that's one thing. And then we have...
So do I-140 is not required, Emily, according to this bill?
Let me look back to that provision.
Because I only see that they gave only exemptions to the children are included when the I-140 is approved. That's the way I'm reading. It's 370 pages bill, though.
Yeah. So, authorized.
Because otherwise, it's going to have a lot of...
Yeah, it does require the main H-1B holder to have the approved I-140, like
yeah,
current,
but
kids are allowed to get it.
Yeah, previously children were not allowed to get an employment authorization. They're going to get employment authorization. And also it protects the age-out kids. If the child has been on H4 for a period of 8 years, though, that means that they must have an I-140 approval. Otherwise, most probably they will have an I-140 approval. I mean, there are some exceptions to the I-140 approval where 7th-year H-1B based on the perm pending also will be eligible for the EAD application, though. So if the children have spent 8 years on H4, though, they would be eligible for the Child Service Protection Act. That means that they could be included at any point of time in adjustment of status, even if they become 30 years of age, even if they become 40 years of age. If the parents' priority date becomes current, they're going to file the 485 application. The children would get the green card, so which is good provision in that thing. Now, coming to the 18,000 green cards. So I know a lot of Indians are criticizing, while Indians are going to only get 7% of them, which is approximately around 1,200 or 1,400 green cards. Well, I would rather take 1,400 green cards per year rather than not take anything at all. And it
Yeah, I mean,
also,
a lot of these bills usually have taking away green cards or trying to make it harder or more restrictions on H-1Bs. So the fact that this bill doesn't have any kind of new restrictions and adds green cards for a temporary period, and not only on the Child Status Protection Act allowing age-out kids to still file and receive the green card, they actually can stay in status after they turn 21 and continue. So if someone has aged out, changed to F1 status, if this bill passes and they were previously in H4 status for 8 years, they could actually change status back to H4 and continue and get automatic work authorization and keep going in H4 until they receive their green card. Now, there's problems with this because that means the main applicant, H-1B holder, now the entire family is still tied to that person. What if they lose their job? Now, the H-4 kid who's 30 years old might lose their work authorization. So there's definitely problems with it, but it is way better than what we have right now.
okay, let's discuss the third topic that we have, Emily.
Well, do we want to talk about, is this even going to pass? Like what happens from here?
Right, sorry. Yeah. What's the chances for the bill?
Yeah, so first off, this is a Senate proposal, which is a good sign because immigration bills usually have to start in the Senate with the Senate Judiciary Committee. So we'll check that off the box. But they're first going to do a test vote supposedly on Wednesday, unless it gets tomorrow, unless it gets delayed. They're trying to see if they can get the 60 votes to pass it because they need 60 votes in the Senate to overcome any kind of filibuster. If they don't do that, then we'll look into, are they going to put it to the floor so people can offer amendments to it, and then it's going to change, and then we have to figure out if we're going to vote for the change. Otherwise, if it can pass through the Senate, now the House has to take up the bill or start their own bill, which could be completely different. And they go through the amendment process, the markup in the Judiciary Committee, decide if they're going to actually bring it to a floor to vote. If the House passes it and the Senate passed version are different, now they've got a conference together to come up with a full compromise, get that passed again by both houses, and then it goes to the president's desk. So we're at the very, very beginning stage. We've seen this many times before, and people say, oh, it's failed before, it's going to fail again. That may be the case, but I still consider it to be progress because this is the first time we've had real legislation that deals with the age out issue. That's the first real time. We've got a separate bill that did talk about that, but this one is actually possibly getting a vote. It's never happened before. The fact that people are aware of this issue for aging out kids and trying to fix it, I think that means something. And then my opinion is it's bipartisan. Again, it started in the Senate and neither side really likes it, which to me means it's actually a good compromise. Nobody feels like they've won, and it might actually have a shot. I don't know. What are your thoughts?
Yeah, now Mitch McConnell, the Senate leader, is backing off, saying that it has no chance of passing. So looks like House is dead. Senate leader is saying. However, though, I feel that there may be some tweaks to get this bill passed because they need this not for the business immigration purposes. They need it to control the border. They need it to fund the Ukraine. So somewhere they have to agree. As far as the immigration part of the business immigration part of it is concerned, we're aging out, kids stopping, and also having the 18,000 extra green cards, though, every year. I don't think so. They are even discussing about it. I mean, they're not saying it's good or bad. So the discussion is mainly on how the Republicans are saying it's not good for the border. They need to do much more for the border. And the Democrats are telling that, well, they're doing too much at the border. So those are the main discussions that are going on, but not on the business immigration. So if there is an agreement, which both people want their side of their things to be passing through, the Ukraine funding and also the border control, ours should not be touched is what I'm thinking about. Should be passed through. That's what I'm thinking about. So if there is any bill that's going to be passed on the border, we may have our advantage. If there is any bill that's going to be passed on the Ukraine, so we may have some good benefits coming out of it. But at this point of time, as it stands, Emily, it looks very weak to pass. Emily, with
right.
regards to the H1B, let me ask you some question. I'm working for company A. So between company A on H1B, let's say, and I want to move to company B, I can have a gap of 60 days. Everybody knows that. Now, if I use 60 days to move from company A to company B, and I start working within that 60-day period, I start working with company B. When I move from company B to company C, can I still have that 60-day, or is it only once in a lifetime for me?
Yeah, you can get it again. Anytime there's a cessation of employment, you get the 60 days. There's no restriction on it. It's only a one-time thing.
What if I am I'm with company A? I take a break for 60 days. Can I join company A back within that 60 days, or that's not allowed?
I think it depends on whether company A withdrew the H-1B. If when you say took a break, it's because you were terminated or you resigned, and because of that, the company withdrew the petition. You can't just go back to company A. They have to file a petition first. But if it has not been withdrawn, yeah, there is an opportunity for you to go back. I think that just going back alone may not be enough to put you back in status. You might want to travel, use automatic revalidation, use your margarita switch to reset the time period for when you have to show your lawful status going forward for purposes of a later extension or the green card application and things like that. But it's definitely doable to go back to the same company within the 60 days.
So this 60-day grace period, guys, is allowed from moving company A to company B. You can get 60 days. Company B to company C, you can get 60 days. Company C to company D, you can get 60 days. It's every time you do it. It's not once in a lifetime. So please consider that as every change you can do the 60 days. Let's go
I
to the
would just
fourth
add
topic.
one caveat to that, and that's if you move from company A to company B within the 60 days, you started working for company B, company B's petition is pending, and then you want to move to company C. Do you get a fresh 60 days there? I don't think so, because it's per approved petition and company B's petition is not approved yet. So that's where it gets a little risky, is if your transfer to company B is still pending and now you've got an even better offer and you want to move on to company C. Or a lot of times people join company B because they think that's all they've got, and then they end up getting the real offer that they wanted. So you've got to be careful about that. Maybe you have to wait for company B's petition to be approved before moving on again.
Let me go to the fourth topic, is how to apply for the green card for parents. Though this is only for the U.S. citizens. The U.S. citizens must be 21 years of age, and they can apply for the green card. The priority date is all the time current. I mean, there is no priority date at all for them. And there is no numerical limitation for them. Now, there are two processes. One is the consular processing. One is the adjustment of status, which most people know. Consular processing means you file an I-130, you send the application to your home consulate, and they will get the green card there. And the adjustment of status is that when the parents are here in the United States, you file for their 485 application while they are in United States. There are some advantages and there are some disadvantages in both of those processes. Emily, I'm going to say some of the advantages of filing the adjustment of status in United States, and please correct me any of those things. The advantages of filing the adjustment of status in United States is when the parents are visiting and they are here in United States, you can file the 485 application. However, they cannot come into United States. They cannot come into United States with an intention to file the green card, which is adjustment of status. They cannot enter with that intention. Now, if they come here visiting with two-way ticket, they can change their intention. They can change their intentions once they are in United States. Why it is very important is that if a person is coming on a B2 visa and they are coming with an intention to settle in United States, they will be deported. Now, how do they come to know the CBP at the border? There are a lot of ways. They can, I think so, they tap into the WhatsApp, the email. I think so, they listen to all our phone conversations too. And they can have the evidence that you are coming here to permanently settle in the United States. They can just ask your parents, hey, what's the purpose of your coming? And the parents might say, I'm coming here to get the green card. And that they're going to put them in the detention for 1 or 2 days, and sometimes the same day they will send them back to the home country, which you don't want that to happen. There are many ways they will come to know. So what is important is that the parents cannot have intention to come and settle in the United States. But once they come here, they can file the adjustment of status. Now, when they file the adjustment of status, the minus point is that they cannot leave the country until they get the advance parole, which sometimes might take about 1.5 years to get an advance parole. So the parents are here on visiting visa with an intention to come and visit you, and they change their intention. You file the 485, they cannot leave the country. If they leave the country, this 485 will be automatically denied. So they have to wait until the advance parole comes in. That's one of the major disadvantage I see. I file the green card application, and the parents will say, I want to go to India, and they cry and whine, and that becomes completely a mess. If you try to go, this whole application will be thrown out. The person cannot come back on a B2 visa because the intentions have changed, and you have to file the consular processing. That's the main disadvantage. The advantage is that the paperwork is more easier if they are in the United States, and they get an employment authorization, and they can stay here even after the B2 expired. Once you file the adjustment of status, they can stay in United States. So these are the main things. Travel, going outside the country is the major disadvantage. Now, when it comes to the consular processing, though, you can do consular processing. Of course, the only problem is that while the consular process is going on, they are not supposed to travel to United States on a B2 visa. The reason why they cannot do is now their intention has changed. They want to settle in United States. You're filing an I-130 application. You're telling the immigration that they want to settle in United States, and they're coming here on a B2 visa. There is a good chance that they may be sent back to home because their intention has changed. They may be detained in the airport and sent back to home. That is where the main problem comes in, is that once you file an I-130, their travel into United States will become impossible. Now, the time process it takes for the consular processing is approximately around 2.5 years for them to get the final green card. Anywhere between 1.5 years to 2.5 years is the time process that it takes for them to get the green card. In the interim period, they cannot come into United States. So here is the problem. For consular processing, they cannot come into United States. For adjustment of status, they cannot go outside United States. Those are the main disadvantages, though. For the consular processing, it takes, the paperwork is not some cumbersome, but it's much tougher than that of the adjustment of status. Go ahead, Emily. Cover anything that I said, good or bad in this.
Yep, I agree with all of that. One of the questions someone had about parents having an approved I-130. So it was filed by the parents' I-130 because it was filed by their uncle, and it was approved back in 2016. They haven't received any communication after that because of an address change. What are the options now? Well, I don't know what the priority date is. If it's somewhere around 2016, it's nowhere current in the F4 category, and that explains why there's no communication. There's nothing for them to do until the filing date is about to become current. Then the NVC will reach out, and that's by email. So I'm assuming they haven't changed their email address. But you can always reach out to the National Visa Center on that to make sure that they have the updated contact information. There's a public inquiry form for that.
Kiran has this question. He's filed the I-485, I-131, I-765. I-765, which is employment authorization, has been rejected. Will it affect the I-485 and I-131 processing time? No, I don't think so. It's going to affect. You can refile the I-765.
Lakitha says, I'm currently in my 6th year of a cap exempt H-1B. If I apply and get picked in this year's lottery, will my 6-year clock reset, or should I have an I-140 approval by the end of the 6th year? Great question. The cap does not reset. So all the time that you've spent in a cap exempt H-1B will count towards your 6-year limit when you switch over to a cap subject H-1B. So you still need to have an approved I-140 by the time your 6th year will be reached.
Ravi Kumar Dega has this question. Can you clarify, following the I-140 approval, is there a requirement that I have to stick with the company for 180 days? Does that 180 days includes calendar days or includes only working days? It's not a requirement, but it's definitely very good for you to stay for the 180 days. Because if you don't stay with the company for 180 days, if the company withdraws the I-140, now once they have withdrawn the I-140 within 180 days, you cannot use that I-140 for extending the H-1Bs. You cannot use that I-140 for getting the H-4 EAD for your spouse. So you, after 6 years of H-1B and you don't have any other I-140 filed before, if they withdraw it within 6 months, you will have to leave the country. So for that reason, you need to stick with the company for 180 days. And also for H-4 EAD, you need that I-140 approval.
Raj says, I'm in the U.S. on an L-1B visa. My H-1B has been approved without the change of status. What is the form that my petitioner, the company, needs to file to get the change of status inside the U.S.? So the same company that got the approved H-1B without the change of status needs to file basically the exact same thing. File the I-129, the whole petition all over again. They could potentially reuse the same LCA or do a new LCA if anything has changed. But they file an I-129 petition again. The only thing that's different here is they're going to check a different box on page 1 of the form. But the full filing fees have to be paid again. You may want to do premium processing depending on when your L1 expires or when the H-1B is expiring. But yeah, they basically refile the H-1B petition, this time requesting the change of status, and then it will happen while you're in the U.S.
J.S. Iyer has a question. His priority date is March 2022. Can the cross-country chargeability based on spouse country of birth be filed even after the I-140 is approved? So yes, answer is yes. So even if your wife, even if you got married after your I-140 is approved, let's say, for example, you're from India and this lady is from Pakistan. And not a good combination, but anyway, this lady is from Pakistan. So she was not your wife at the time when you filed an I-140. Can you use your wife's country of birth for the cross chargeability, saying that now your date is current because of you're married to Pakistani girl? Can you file the 485 right now? Absolutely, you can. No problem, none whatsoever at all. In your case, though, J.S. Nair, March 2022 EB2, it is current if the lady that you married is from other countries other than India and China. You can definitely file the 485, even though you may not have been married at the time when you filed the labor certification, at the time when you filed the I-140, at the time when you got your I-140 approved, you are not married. But now you're married with this lady, you are eligible to file the 485 because your date is current.
AK says, I'm currently on an H-1B and I'm investing as a partner in a startup LLC. The business is just starting, no sales, no active income is expected for another 3 years. Will there be any issues with the green card? So it's not so much a question of sales or income. It's a question of what are you doing for this LLC? If you are just a passive investor, you gave the money, you got your shares of the company, and you eventually get some income from it, and you don't do anything else, that generally is not considered work without authorization, and therefore should not have any problem for your green card. If, however, you're investing as a partner in this LLC and you're the one going around to the bank to get the loan for the purchase of a property, or you're signing paperwork on behalf of the LLC is hiring people and you're doing the interviewing for those people, filing H-1Bs on behalf of people, and you're signing as a member of the LLC, that is all very problematic. That's work without authorization. That will be a problem for your green card. So it all revolves around whether you are doing work without authorization, because your H-1B only allows you to work for the company that sponsored the H-1B. Any work that you're doing outside of that is not authorized and can cause a 485 denial.
Rajat company has applied perm in January of 2024. His max out is May of 2024. Can I get a 7th-year extension after 365 days if I'm in India? And after H-1B max out, can I work in US payroll if I'm in India? Let me answer the first question. Can you work in India after May of 2024? Because your 6 years is over, you're in India right now. Answer to the question is that when you are in India, though, you can work. With regards to the payroll, I would recommend to consult an immigration lawyer or an accountant CPA. That's a different issue, though. But as far as your work is concerned, even though you don't have an H-1B, even though you maxed out in May of 2024, you can continue working in India for a US company. And yes, you can, because the reason is that you are in India, you come under the jurisdiction of India. Can Indians work in India? Yes, they can work. They don't need any permit from Indian government. It's automatically permitted. Indian citizens can work in India. They don't need any work permit. Now, coming to the question, do you need any work permit from USA? You do not come under the US jurisdiction. You can, since you are working remotely though, okay, we do not consider that at all. We consider where your butt is sitting. Since your butt will be sitting in India and you're an Indian citizen, you can continue working. With regards to the payroll, I want you to discuss with an immigration lawyer privately how to deal with regards to the payroll. Now, 7th-year extension. Let's say in May of 2024, you go to India, you stay there. Now, January of 2025, your labor has been pending for more than 1 year. Can you get 1 year H-1B while you're staying in India and get the stamping and come back into United States? Absolutely, you can. No problem. Once the labor has been passed, it's more than 1 year that the labor has been filed, you can get the H-1B, you can get the H-1B stamp and come back into United States.
And you don't even have to wait until the labor has been pending for 1 year to file that petition. You could file it up to 6 months in advance, as long as your start date that you're requesting is at least 365 days from when the labor was filed. So that can save a little bit of time, because you can get the approval and get the visa stamp and then come in right on day 366.
Emily, this point, some of the lawyers refuse to file before 1 year. What to do with them?
I don't know. We do it all the time.
You need to get them to watch our videos, guys. These lawyers who refuse to file before 1 year. As Emily pointed out, if you have filed in January, you can file in July of 2024 with a start date of January, that is after 1 year that the labor has been filed. If they don't agree with it, tell them to watch this video.
All right. Monica says, can we apply for the H1, H4, and H4 EAD? The H1 is in the US, but the H4 is in India in regular processing and upgrade later to premium processing. So first question is, can you file in regular and upgrade to premium? Yes, no problem with that at all. Just know that the filing fee is going up February 26th. Thinking of doing that, you may want to upgrade before February 26th rather than after. However, if the H4 outside the US, you cannot file of the H4. They have to be physically in the US, both to file an H4 extension and to file the H4 EAD. So that will not work. So you can apply for the H1 in premium, get it approved, your spouse can then apply for the H-4 stamp, and that's how they get their extended H-4, come into the US and file the H-4 EAD. And if the first H-4 EAD has not yet expired, when they're filing the H-4 EAD, that qualifies them for the 180-day auto extension because they already got the H-4 extended through the consulate rather than by filing an I-539. If they're outside the US, you cannot file an I-539 to extend someone's H-4.
Question that comes in is, how is the 1099 different from Robinhood and W-2 jobs? I'm just checking it. It looks like definitely getting 1099 for the non-immigrant visa people for Robinhood, not a problem at all. Go ahead, you guys get the 1099. You just have to pay the taxes. Absolutely. With regards to the W-2 jobs, I think so. When I see it says, it is for the bank, it says that it is interest, 1099 INT. That's what it says. But when 1099 as an independent contractor, though, is if you don't have a proper work permit. For example, if you're an H-1B, you're working for company A, can you get a 1099 as an independent contractor? The answer is no, you cannot. You can't have an independent worker on the H-1B, L-1, O-1, and certain other non-immigrant visas. On H-4 EAD, though, you can get it. On the GC EAD, you are allowed to get the 1099, but not on H-1B and L-1 visas. Independent contractor. But yeah, go ahead, Emily, sorry.
Man, she says, I'm on OPT EAD right now. I have 2 job offers. One's from a nonprofit organization that's affiliated with a university, and the other is from industry. So I'm assuming you mean for-profit. On the basis of future H-1B sponsorship, which one should I accept? Well, remember that the for-profit company, they first have to register you in the lottery, and then you have to actually be selected in the lottery, and then they file the petition. And it only starts October 1st, 2024 at the earliest. So that's one thing to consider versus your nonprofit organization, assuming they qualify as cap exempt, since you mentioned it's a university, they can file your H-1B today, and you can be in H-1B status 15 days from now and not have to worry about the lottery at all. So that's one thing to consider, is whether you want to deal with the lottery or not. Even though you go with the nonprofit, you can still have the for-profit go through the lottery. And if you get accepted, great. If you get selected, I mean, great. If not, you can continue with the nonprofit. While you're working for a nonprofit cap exempt H-1B, you can simultaneously work for a for-profit company on H-1B if the for-profit company files a concurrent H-1B employment for you. And that does not have to go through the lottery. So as long as you're working for both at the same time, the for-profit company does not have to go through the lottery. So that's another thing to consider.
Sujit Kumar has this question. Will my approved I-140 NIW, National Interest for, affect my spouse's ability to get the J-1 visa stamping in India? That's a tough question, though. Now, in the DS-160 form, they will ask, have you filed an immigrant petition? She didn't file an immigrant petition. So, but what about the question, Emily? Is somebody else filed on your behalf? As answer for her, for both the answers are no for her. So she doesn't have to disclose that she filed an I-140 because she didn't file an I-140. But if the consular officer knows, yeah, it may affect that you filed an I-140, it may affect the J-1 visa, though.
Rena says, can I use the national interest waiver if I already have EB-2? I'm assuming that's what the question is. So yeah, just because you already have an EB-2 I-140 petition, you're still eligible to apply for another EB-2 I-140 petition under the national interest waiver category. Now, why would you do that? Obviously, it's not going to give you a better priority date. Your priority date's going to stay the same. It's not going to improve your place in line because it's still EB-2, but you're not tied to an employer when it comes to the green card if you have the NIW I-140 approved. So let's say you're on H-1B, you're at the end of your 5th year, and the employer that filed your EB-2 I-140 lets you go. Maybe it's less than 180 days since your I-140 approved, and they withdraw it. Now you have nothing. versus if you had your own NIW I-140 approved, also in EB2, you're still fine because you can transfer to any other company, utilize your own I-140 to get the 7th year, 8th year, 9th year extension and keep extending your H-1B based on that, and not have to be worried about having a new employer file the perm and make it through that process in the I-140, because that takes 2 years. So there are definitely benefits to having an NIW I-140, even though it's still EB2, even though it's still subject to the backlog. It can be useful.
Question: how likely is HR 6976 to be approved? We don't see a lot of voices raising this way or that way, though. The headlines are all covered with the border bill. This HR bill 6976 is not there anywhere. We don't see any senators commenting, I'm going to support it, I'm going to present it, I'm going to oppose it. We don't see any of those things, though. So it will depend. If some senator is strongly supporting it, he may take it to the Senate, and then there may be some discussion. At this point of time, we don't see any chatter going on in the Senate. So we'll keep updating if something pops up on this one, though.
Zaref says, if my perm application gets denied while I'm in my 7th year H-1B that I got based on having my pending perm for 365 days, will my H-1B actually be revoked? Because now you no longer have that perm that was pending for 365 days. It's been denied. The good thing is, no, they do not go back and revoke the 7th year extension, even though the underlying basis that you got it on is not there anymore. The bigger issue is, how will you get your 8th year extension? So for that, you may need to consider filing an appeal of the perm. So it gets to BOLCA, where the processing times are terrible, and it will continue to be pending. So you can get your 8th year extension while you figure out if you need to file a new perm in order to overcome the reason for the denial.
My wife's H4 extension is pending for more than 6 months. Though my H-1B is approved, how long she's allowed to stay in USA after visa expiry? Assuming that she filed the extension before her I-94 expired, she can stay until the case is adjudicated. There is no limit that she can only stay up to 6 months.
Sumati says, my daughter is turning 21 in October 2024. We filed concurrently, the I-140 and the 485, and the I-140 got approved after 17 months. It says priority date September 22. Can my daughter continue her studies in EAD, or should she move to F1? So not sure on that priority date and what your country of birth is, but how do we figure out whether her age is locked? We look at, on the day the I-140 was approved, was the priority date current? If it was current under the filing chart, then you have to look at, in that month, did USCIS accept the filing chart? If both of those answers are yes, then her age is locked. If the date is not current at the time the I-140 is approved, her age is not yet locked. Then you need to figure out, okay, if she's turning 20 in October of this year, the I-140 was pending for 17 months, so that gives her 17 months extra time to see if the final action date or filing date become current. If that's likely, then she may not need to move to F1. But if it's pretty clear that the final action date or the filing date is not going to become current by the time she turns 21 plus 17 months, then it may be better for her to switch over to F1.
Are traffic violation speedings are also part of the DUI? No, they are not. They definitely are not, are now.
Kieran says, if I filed for the 485, 765, and 131 altogether, but then the 765 got rejected for some reason, does it have any effect on the processing time?
I already answered
that one?
Yeah.
All right. Let's see. Murtaza asks, what is the maximum legal time an H-1B employee can work remotely from India due to the aged parent health issues? So as Rahul kind of mentioned earlier, you're in your home country, so there's no restrictions on you working in your home country. Now, what is the maximum time where it won't impact your H-1B. Obviously, your H-1B is going to expire at some point. So if you come back before your H-1B expires, then you're here and you can file your H-1B extension as normal. But even if your H-1B expires and you later want to come back, you still can. You just need your employer at that time to file an H-1B petition that's not subject to the cap because you've already been counted, consular processing because you're outside the U.S., and then you get the visa stamp and come back to the U.S. Now, if you're doing this based on an approved I-140, you do need to make sure that you get back into the U.S. and H-1B status before your priority date becomes current. Because once your priority date becomes current, if it stayed current for 1 year and you've not proceeded to file the 485, then you may not be eligible to get further H-1B extensions.
Very good question that came from CEO Sonic Solutions. Will the bill be considered past violations or future violations? That's surprising. The bill doesn't leave the people who have past violations also are covered in this one. That's a big problem for the past violations, though. Since it's an immigration bill, they normally go to the past violations too. So it covers both past and future.
Jervesh says, when I go to the I-94 website to get my travel history, it says no record found. I came to the U.S. in 2015 on an F1. Now I'm on H1. What can I do? And is there any concern? So I would, number one, make sure you're using, check all your passport numbers. So if you traveled previously on an older passport and you've since renewed your passport, check under your old passport number as well to see if it comes up. But if your I-94 comes up, fine, and it's your travel history that does not, don't worry about it at all. It doesn't mean anything. It's more just there for your convenience, but then you don't need to take any action. As long as your I-94 info comes up, you're fine.
I was on H4 visa. My H1B got approved in December 2023, received notice of intent to revoke for multiple registrations, went to Mexico, re-entered using the H4 visa. So what happens to revocation of my H1B visa? Do I need to apply the change of status? No, you are already on H4 right now. The H1 revocation will not have anything to do with the H4. You still are on H4. They are not revoking the H4. You already came back on H4, so you don't have to reapply for H4.
Raj Kumar says, currently I'm working on an L1 and my company is starting the green card process. At the same time, they want to put my name in the H1B lottery this year. Can I change L1 to H1B without exiting the US? Potentially, yes. So as long as you're maintaining your L1 status at the time of filing the H1B and it will continue through at least September 30th, then yeah, you're always eligible for a change of status, assuming you are selected. But remember that all the time that you spent on L1 counts towards your H1 6-year limit. And if you actually utilize all 5 years of your L1, you're not eligible to get H1, even if you have an approved I-140. So make sure you don't actually hit the limit of L1B time. Leave some days, and then that way when you have your approved I-140, you can use it to get the 3-year H1B, even though you've used up 4 years and 364 days of L1 time.
Currently having concurrent H1Bs, that means this person is working for more than one companies. Will there be any impact when I attend the visa for stamping? Absolutely not. I mean, working for 2 companies at the same time is nothing wrong, guys. You're doing something great, not bad, and legally perfect, though. Now, the only problem, Vijay Verma, is that when you come back into United States, they don't give permission to work for 2 companies. You can only work for the main company. So let's say you're working for company A and company B, and company B is on the concurrent. Company A is the main employer. You get the stamping for company A, you come back into United States, then you can only work, once you go outside the country and come back, you can only work for company A. If you want to work for company B, as soon as you enter into the United States, company B has to file one more concurrent H1B so that you can continue working for that company.
Laksh says, I have an I-140 with company A, and now company A has been acquired by company B. Do I need to do anything to continue my green card process with company B? Yes. When there is a successor in interest, which this case would likely qualify because the whole company was acquired, the new entity, the acquiring entity, is required to file an amended I-140 petition. They use the same labor certification of the old company. They refile application documents, all of your experience letters, and then they have to establish that they are a successor in interest by documenting the transaction that occurred. And more importantly, they have to document that they have the continuing ability to pay from the date they acquired the company going forward. That's the ability to pay the salary that's on your labor certification. So it's just basically a matter of refiling that I-140 petition, making sure they do have the ability to pay. And you need to get that done before your priority date becomes current, so it's taken care of by then.
Yeah, Santosh has a DUI in 2014 and he wants to travel in June of 2024 for H-1B stamping. Does the new bill, with the new bill, should I travel? If the bill goes through and becomes a law, I mean, that's a one-way ticket for you. You're not coming back. But if the bill right now, it's just passed in the House, it still needs to be passed in the Senate, and the president has to sign it. But once it becomes a law, you are not, once you go, you're not getting the stamping.
Contrasec says, concurrent H-1B and the impact on the green card process. Is it required to submit the concurrent H-1B details during the green card process, even though the green card is done by the primary H-1B company? Yes, on the 485, they ask for all employment within the last 5 years. So you cannot leave off your H-1B concurrent employment. And when you list all of your employment, you need to document that it was all authorized. So that means you do need to submit the H-1B approvals for your concurrent employment.
There are some ways to, are there any ways to amend it, Emily, once they file? Let's say, for example, this gentleman is working for company A, which is Coca-Cola, and he's working for company ABC on the side. Let's say he doesn't disclose that information when he's filing with the employer's lawyer. Could it be that he can send a supplement of the I-485 after filing the 485 so that he can mention in that way he doesn't need to disclose at the same time, he's not telling a lie to the USCIS?
Yeah, you can definitely interfile. So you basically take that page of the 485, make the updates to it with the corrected information, and provide your missing H-1B approval notices that were not submitted before, and ask USCIS to add it to your file so it can be looked at when they do the adjudication. Clevy26 says the grace period expired December 15th, and H4 and H4 EAD were filed November 15th, so 1 month before. Those are still pending. Then got the new job, filed the H-1B transfer, and was approved on January 15th. Does the November 15th to the January 15th count towards the 6-year max out? It depends. So when the new job was filed for the transfer, was it within the 60-day grace period after December 15th? If yes, if you're counting on the 60-day grace period to be eligible for that transfer, then yes, it counts towards your 6-year limit because you are considered to be in H-1B status during that time, even though you filed an H-4 and H-4 EAD. If instead you filed the H-4 or H-4 EAD, stopped working during that time from November 15th, and filed the change of status back to H-1B after the 60-day grace period expired, and you were relying on the H-4 and H-4 EAD pending to keep you in a period of authorized stay, then that time you were in the period of authorized stay does not count towards the 6-year limit because you were not in H-1B status during that time.
My employer attorney says they can't file the H-4 EAD under AC-21, POM pending for more than 365 days. I want to file with, I wanted to file H-1B 7th-year extension in premium. They want to wait until the H-1B extension is approved. Absolutely crappy lawyer. Absolutely crappy lawyer. No, you can
It's so
file
clear.
H1, H4, and EAD together along with the 7th year extension. You do not need to have an I140 approval to file the H4 EAD. The 1 year of POM pending, not only 1 year of POM pending, it must be 7th year of H1B. That's another requirement. The 7th year of H1B, you can definitely file the H4 plus EAD. Absolutely not a problem. I don't know why they want to wait. And it's advantageous for you to file H1 and H4 plus EAD together. If you file with that company, you're going to get the H4 and EAD together along with the H1B. But if they file the H1B and you come to us for the H4 plus EAD, ours is going to go normal processing and you lose the premium processing option for the H4 plus EAD.
Sandeep says, I've traveled to India and entered using my GCEAD. I'm assuming you mean advanced parole that's on your GCEAD. And my new I-94 is expiring 1 year before my H-1B. Do I need to refile my H-1B because my new I-94 is expiring 1 year before the H-1B I-94? No, you don't. The good thing with that. So when you enter on advanced parole, it's normal that you just get a 1 year I-94. But if you are continuing to maintain your H-1B status, you're working for the same employer under the same terms and conditions, same job, same salary, same work location, you can consider yourself to be in H-1B status, and you only need to file the extension when your H-1B I-94 is expiring.
Priya, can you be on bench and not get paid for 60 days on H-1B? Answer is no. That is not allowed. There's a lot of questions coming on unemployment on the 485 application. Once they file the 485, I would request that you contact an immigration lawyer one-on-one on the unemployment, though the reason is that there is no 60-day grace period. There are a lot of exceptions available. You can have a self-employment and you can have a job offer. They can save you to get the green card, though. But there is no 60-day rule for the adjustment of status EAD. There is nothing like that.
Gokul says we filed H1 and H4 together in July and then upgraded to premium processing in September and got it approved. 2 days later, the spouse's H4 also got, the son's H4 is still pending. What will be our options? So your employer only, or the employer's attorney that filed your H1B, can try to contact the premium processing unit that should have approved the son's H4 along with it. That's the only thing that can be done. As you as the H4 or you as the H1B cannot contact USCIS. Your spouse can contact USCIS about the H4 only, but they'll just say there's no premium processing for H4. What are you talking about? So really the only way to do it is to have your employer or their attorney contact USCIS. Hey, it should have been approved together based on USCIS's own bundling policy.
My current status is H4 EAD. Can I work for the company that is in Dubai? Absolutely, you can. No problem. Since you have an EAD in United States, you can work remotely anywhere. You're perfectly all right. You are on H4 EAD. You have the work authorization.
A. Kumar says, I filed my AP renewal back in June 2023, still pending. In December 2023, I renewed my passport. Do I need to send my new passport information to the already applied AP renewal application? No, you don't. The good thing is any passport renewal that happened while an application is pending with USCIS, you don't need to take any action with that. They can still approve based on the previously submitted information.
Can there be a part-time H-1B, 20 hours a week, special situations? Yeah, absolutely. There are possible. There are some people that only work for 20 hours. It's possible. But it needs to be a genuine employment and not a fake employment, though. And it's not like they sponsor you for 20 hours and you are working for 40 hours and they're only paying you for 20 hours. That's not allowed too. Anything else, Emily?
Oh, I guess it's time. Let me answer this last one. Kalyan says, my wife's H-4 extension is pending for more than 6 months, even though my H-1B is approved. How long is she allowed to stay in the U.S. after her H-4 expires? She can stay as long as it's pending, assuming your H-1B remains valid. But thanks so much for joining today. As always, we do have a daily conference call that you can join in order to get your questions answered in a smaller group setting. You can go to rnlawgroup.com to get that information. And you can always set up a consultation if you need any more specific information with myself or any of our attorneys here at Reddy Neumann by going to rnlawgroup.com.
Thank you guys for coming in.